Good morning. Nice to be back.
Good morning, Lordship. If I may, Your Lordship.
Yes.
Yes, regarding part 2, item number 3. Yes. I'm on behalf of my senior, Mr. Victor Irate, Your Lordship.
Okay.
And if this matter be taken up any other day.
Which item?
Except today, item number 3, part 2.
Item number 3. Okay. Any other day means?
Except today, Your Lordship.
Thursday? Thursday.
The two matters fixed on Thursday already.
Okay, then tomorrow?
Your Lordship.
Tomorrow, okay.
Obliged.
May I please assist Your Lordship?
Yes.
We would like to make a mention of item 11, part 2.
Item 11. Yes.
If the matter may kindly be fixed next Monday, my lord.
Next Monday.
Yes, my lord. We'll have it fixed.
Okay. You are for the petition. You are amicus.
I am amicus, my lord.
Okay. Learned amicus, Miss Valentina Laltinpui has prayed for listing the matter on 1st of September, with the consent of the other side. Stop. Who is PP? Okay, Learned PP such and such is present and there's no objection. List on 1st September. Yes.
Much obliged.
Daily list for motion, item 1.
My Lord, in this matter, the leading counsel, Mr. Farish, will be appearing through VC. And, my Lord, he has some matters in the Supreme Court. So can the matter be passed over for the time being? And
Okay,
after
time
the
being.
daily item?
We'll call after something.
Yes, ma'am.
Yes.
I'm obliged.
For admission, item 3.
My Lord, this matter is more or less a covered matter, in the sense that, my Lord, what happened is that the rehabilitation and resettlement scheme for displacing the petitioners was prepared by the state respondents in accordance with the 2016 Mizoram Land Acquisition Act. Now, what happened is that, my Lord, the 2016 Land Acquisition Act was held to be made inapplicable by a coordinate bench of this court. And subsequent to that, the state respondents had filed an appeal before the Honorable Division Bench, which was subsequently dismissed.
Okay.
And after the dismissal of the writ appeal, my Lord, the state respondents have again preferred a review petition. Now that was also dismissed.
That also
Now my only prayer in the writ petition is that the rehabilitation and resettlement scheme should be prepared in accordance with the 2013 new LA Act, the right to fair. Yes, the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, instead of the 2016 Mizoram Act. Yes. That is my only prayer, my Lord.
Yes, government.
The leading counsel, the GA, is on legs. If it can be passed over for the time being, Madam.
If that's the case, then it's covered, isn't it?
Yes, yes. But I think maybe she has something to say. She has asked me, requested me to pass over.
Okay, okay. Call after something.
Item 4.
Yes.
I think, my lord, in this case, the council has agreed that the matter be listed on Thursday for disposal, if this court allows me that.
On Thursday. What is the matter about?
My Lord, here this matter is taken up by the learned senior counsel, my Lord. I am not...
Otherwise, affidavit in opposition filed. Pleadings complete.
My lord, the council is, the GA is indisposed today.
Okay. Then we'll pass it over.
It may be taken up again on Thursday, my Lord.
Okay.
Thursday, I
list-
think it's ready for disposal.
Okay.
I have
The
been informed.
learned government advocate. What's the name? Just give the name.
Miss Mary.
Such and such. Mary is indisposed today. Accordingly, list the matter on Thursday. Yes.
Item 5.
May I please, Your Lordship? Steps have been taken, and however, the registered AD card has not returned from respondent number 1 to 7, my lord.
Learned counsel for the petitioner, MS such and such present, as per the office note dated 22/8/2025, the unserved notice, the service report / unserved notice has not returned back from respondents 1 to 7 till date. Stop. Accordingly, list the matter after 3 weeks awaiting service report on respondents 1 to 7. Yes, oblige.
Item 6 for orders.
My lord, in this case, steps has been taken for service of notice to the respondent on 37/25. However, AD card has not returned back. So if it please your lordship, we may wait for the service notice.
Learned counsel for the appellant, she such and such present. Stop. As per office note dated 22/8/2025, the service of notice is still awaited on the respondents. Stop. Accordingly, list the matter after 3 weeks awaiting service report.
Oblige.
Item 7.
May I please, my lord, as per the office note dated 22/8/2025, AD card upon the respondent number 2 is not returned yet, so if service may be awaited.
Learned counsel, MS such and such present for the appellants. Stop. The office note dated 22/8/2025 indicates that the service report / AD card has not yet returned back from respondent number 2 till date. Stop. List the matter after 3 weeks awaiting service report on the respondents.
Oblige.
Item 8.
My lord, here there is a delay of 889 days in filing the connected make appeal, my lord. This is the first time it has come up.
Okay. This is an application under Section 5 of the Limitation Act 1963, praying for condonation of delay of 889 days in filing the connected MSC appeal against the judgment and order dated 14/12/2022 passed by the MSCT Aizawl, Mizoram, in MSCT case number 42 of 2019. Stop. Issue notice returnable within 4 weeks. Stop. The learned counsel for the appellant shall take steps for service on respondents 1 to 7 by registered AD as well as usual process within a period of 3 working days from today. List after 4 weeks.
My lord, if I may be allowed to take Dusty with respect to respondent number 7. They have their division office here in Aizawl.
Okay. Regarding 7, you say for respondent number 7, the appellant is allowed to take steps by Dusty and to file compliance of affidavit thereafter. Then for the others, registered. Okay.
Oblige.
Yes.
Item 9.
Yes, who's there for the appellant? None appears for the appellant when the matter is called. List after 2 weeks.
Item 10.
My lord, these IS are all condonation application fund.
Okay. Notices complete.
This is the first time that
First
this
time.
case has been listed.
This is an application under Section 5 of the Indian Limitation Act. praying for continuation of delay of 155 days in filing the connected appeal against the impugned judgment and order dated 17/12/2024, passed by the Additional District Judge Aizol, Kolasip District in LA case.
Yes, ma'am.
LA case number 25 of 2015. So, issue notice returnable within 4 weeks. The learned counsel for the petitioner shall take steps for service on the respondents number 1 to 6 by a registered post with AD as well as usual process within 3 working days from today. What about the government?
They have
Lordship,
received. They
I will
have
be
received.
appearing for the respondent number 7 and 8.
7 and 8. Learned Government Council, MS such and such, accepts notice for the respondents number 7 and 8, and therefore no formal notice is required. So please after 4 weeks. Yes.
This is also, my lord,
Item 11.
Same.
155 days, same case.
Same, but days is different, no?
No, delay is same.
Delay also
155.
same. Okay.
In item number 12, it is 156 days. In item 10 and 11, 155 days.
10 and 11, 155 days, and respondents also same.
Yes.
No, my lord.
12 is 156 days. The respondents are not same.
Respondents will be different.
Yes.
You just see from here. Then item 12,
156 days.
156 days, and different respondents. Okay. Yes.
I'm obliged.
Hearing list, item 4.
This is hearing, no? Hearing this.
Lordship, the other side,
Okay.
they remain absent. It may be taken up, if convenient, tomorrow, Lordship.
Okay, tomorrow we have fixed another matter, but who's appearing? Government advocate?
It's
Or it's private
government
party?
is not party.
Private party. It's reflected in the cost list, the name of the council. Or next week? It's up to you. Or we can see tomorrow also, it's okay.
Tomorrow, let's
Pass
see,
over
if
for that.
possible, yes.
Daily list for motion, item 1.
Yes, not yet.
He has not joined, I'm sorry to say.
You inform him
My lord,
to appear after about 15 minutes, no?
my lord,
Then we'll see.
I'm obliged.
Item 3 for admission.
My Lord, we are going to get information whether it's covered or not, whether we can take it up or not.
Okay. Hearing, what to do? Yeah, that's better, I think. No? Okay, we'll rise and then after 10 minutes we'll come back.
My lord.
Okay.
All right.
Let's go.
If I may seek your lordship's indulgence,
Yes.
I was stuck in the traffic when item 9 was called, my lord. So, and there are certain defect in the IA. So, if your lordship permit, may
Item
I
9, this
be
criminal
allowed to
appeal.
withdraw the same with liberty to file afresh?
This one, no? Oh, okay.
There are certain defect in the IA. I have miscalculated the number of days, and I have also failed to minus the 90 days, the appeal period. So
You want to withdraw?
I want to withdraw with liberty to file afresh, my lord, without withdrawing the RSA, just the IA.
Okay. So IA 140 of 2025, okay. Otherwise we had already passed order, I think, no? So So the other order, you cancel it. Learned Counsel for the appellant, Sri such and such, has prayed for withdrawal of the IA with liberty to file afresh as certain discrepancies are there in the calculation of the dates. So prayers allowed. The IA's disposal on withdrawal. Council is given liberty to file afresh. Yes.
Obliged, my lord.
For motion, item 1.
Tomorrow,
He has joined. He has
it
joined.
appears he's still not around. Pass over. Pass over for the day.
For admission, item 3.
My lord, item 3, it's a covered matter.
Covered case.
Yes, ma'am.
Okay, so where is the other judgment?
My lord, it's covered in a sense that, my lord, this writ petition pertains to the rehabilitation and resettlement, my lord. If you will see
you
it,
were saying that there's another case which
yes,
is
yes,
disposed
my lord.
of.
I'll take you to that, my lord.
Yes, yes.
First, if you will see it, my lord, page 42 of my writ petition, my lord.
42. Okay.
This is the judgment passed by the learned single judge. And if you will see at page 60, relevant portion is at page 60, my lord. Page 60, para 32.
60.
Paragraph 32.
Yes.
May I read, my lord?
Yes, yes. Please read.
In view of the reasons stated above and by way of reading down the Mizoram LA Act 2016 vis-a-vis the new LA Act 2013, this court finds that some provisions of the Mizoram LA Act 2016 regarding payment of compensation and solatium, etc. are less beneficial, repugnant to the provisions of the new LA Act 2013. Further, the new LA Act 2013 has not received the assent of the President. Accordingly, in view of the reasons stated above, this court holds that Mizoram LA Act 2016 is not applicable in the state of Mizoram. Consequently, the compensation to be paid to the petitioners will have to be made as per the new LA Act 2013. Now, after this, what happened is that, my lord, the state went on appeal.
That was dismissed.
Yes, this is writ appeal number 71 of 2018, my lord.
Can you just supply?
In that will appeal, my lord, at para 39, my lord, second last page. The judgment and order passed by the learned single judge was upheld. Now this writ appeal was disposed on 30/10/2024, my lord. This writ appeal 71 of 2018 along with other writ appeals was disposed on 30/10/2024. Now what happened is that, my lord, during the subsistence of this writ appeal, during the pendency of this writ appeal, I had filed the present writ petition.
Okay.
Now in the present writ petition, my lord, the the respondents have made the rehabilitation and resettlement scheme as per the 2016 Mizoram Land Acquisition Act,
Okay.
which was already held inapplicable by the learned single judge. But since the writ appeal was pending before the Honorable Division Bench, my lord, the rehabilitation and resettlement scheme was made as per the 2016 Mizoram LA Act, and not the 2013 Central Act, my lord.
Assessment was already made
Yes, yes.
as per
Assessment
the
was already
16, as per the 16
as
Act.
per the 16 Act, my lord. Now I have challenged the assessment in
Okay,
this
so,
writ
so
petition.
now you want it to be as per the 13 Act
13 Central Act,
in
my lord.
pursuance of this judgment.
Yes, my lord. And if you will see at the
And against this, you were saying another
yes,
SLP
yes,
was
my lord.
referred.
Review petition was
Review,
filed, my
okay.
lord. Review petition 7 of 2025. Now this was dismissed on 19/2/2025. This review is preferred against the judgment of the Honorable Division Bench, my lord.
Okay. So your prayer is
So, my lord.
to go on to show someone to resettlement. So they will have to reassess.
Exactly, my lord.
Reassess as per the 2013 Act.
And if you will see at the counter affidavit filed by the state respondents, my lord. Counter
Yes.
affidavit of the state respondents at para 6 and 8, my lord.
6.
Para 6, my lord. Last sentence of the para 6, my lord. If I may read. The last sentence, my lord.
Yes.
As such, rehabilitation and resettlement award was prepared as per second schedule of the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016, and the claim of the petitioner can be reconsidered as per
As per
final
final
outcome of the said appeal case. So the appeal was subsequently dismissed, my lord.
Okay. Okay, then we'll dispose it off. The present writ petition has been preferred by the petitioners challenging the assessment which was done as per the...
My lord, if I may interject.
Yes.
In my writ petition, my lord, I have mentioned specifically that there are a catena of cases wherein not the rehabilitation and resettlement but the award was challenged in a catena of cases, my lord. That judgment also, if I may furnish, my lord. Here also, my lord, the coordinate bench of this honorable court had directed the respondents to make the award as per the 2016 Act. Sorry, 2013 Act, my lord.
2013.
Yes, yes.
No, in fact, now that the judgment was upheld, we
Yes.
can go by this also, by
Yes,
the
yes.
writ appeal and the review
Yes,
also.
my lord.
Yes. Okay, just say this writ appeal has been filed by the petitioners,
My lord.
whose lands were acquired for the construction of Zaino-Maure-Chapi ZMC Road. Stop. It is the case of the petitioner that the acquisition proceeding was done by the respondents under the Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016. Stop. It is stated that the petitioners were denied the rehabilitation and resettlement compensation as entitled to them under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. Stop. Your prayer page.
My prayer is at page 21, 20 onwards.
It is the prayer of the petitioner in this present writ petition that the respondents should be directed to award the rehabilitation and settlement as per the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013 and not as per the Mizoram Land Acquisition, Rehabilitation and Resettlement Act of 2016. Stop. I have heard learned counsel for the petitioner, Mr. Such and Such, as well as the learned government advocate, Ms. Such and Such. Stop. Para. It is contended by the petitioner that in WPC, where is that WPC?
Page 42, Annexure 7.
in WPC 20 of 2014 and WPC 30 of 2014, this court, while considering a similar writ petition, had directed that keeping in view the new LA Act of 2013, the state government / respondents were directed to complete the acquisition proceeding of the petitioner's lands as per the new LA Act of 2013. Against the said writ petition, against the said judgment and order of this court dated 15/11/2017, a writ appeal was preferred by the state respondents, being writ appeal number 71 of 2018.
71 of 2018 and 70 of 2018.
70 and 71, no?
Madam.
70 and 71 of 2018. And the said writ appeals were disposed of by the division bench on 30/10/2024, upholding the judgment and order dated such and such, that learned single judge judgment, okay, dated such and such, passed in WPC 20 of 14 and 30 of 14. The division bench in its judgment dated such and such was of the view that there is no case for interference with the impugned judgment and order dated 15/11/2017, passed by the learned single judge in WPC 20 and 30 of 2014. Accordingly, the writ appeals preferred by the state respondents were dismissed, and the state respondents were directed to complete the acquisition proceedings under the provisions of the Act of 2013. The state respondents thereafter preferred a review petition, being registered as Review Petition 7 of 2025 against the judgment and order passed in writ appeal 70 and 71 of 2018. By an order dated 19/2/2025, the review petition was also dismissed. In view of the above facts and circumstances, the learned counsel for the petitioner praised that the present writ petition may also be allowed with similar direction to calculate the assessment and to pay the compensation as per the Act of 2013. Learned government advocate in such and such has fairly submitted that the case is a covered case, as its facts and circumstances are similar to that of writ petition 20 and 30 of 2014. This court has considered the submissions of the learned counsels and has produced the pleadings as well as the directions of this court, directions of the coordinate bench of this court, as well as the division bench and the order passed in the review petition, and is of the view that this case is similarly situated. Accordingly, the petition is allowed. The respondents number 1 to 5. 1 to 4 is a statement. 1 to 4. The respondents number 1 to 4 shall assess the compensation due to the petitioners under the Act, under the right to fair compensation and transparency in land Acquisition, Rehabilitation and Resettlement Act of 2013 within a period of 4 months will do? Within a period of 4 months.
If I may interject, my lord,
Yes.
the reassessment should be confined only to the rehabilitation and resettlement only, my lord. Because
Yes,
there
yes.
are other petitions where they were directed to reassess the whole award, my lord. But this petition is confined only to the rehabilitation and resettlement only, my lord.
Okay, okay. So, the state respondents 1 to 7 such shall reassess,
My lord.
shall reassess the settlement award.
Rehabilitation and resettlement
Rehabilitation
award.
and settlement award. Yes, as per the Act of 2013, within a period of 4 months, and thereafter, and 6, 7, and 8 will make the payment, isn't
My
it?
lord.
And thereafter submit the same to the respondents number 6, 7, and 8, who shall make the payments as required, payments / compensation as required within another 3 months. That will do?
2
4
months, my
months?
lord.
3 months.
Let it be 3 months. As government machinery, it takes long. Within 3 months. Stop. With the above directions, the petition stands disposed.
I am deeply obliged.
You
Item
just
1 and 2 if
send
I
it
may,
to
Your
my
Ladyship.
chamber once, okay? We'll make correction again. So just
Item 1 and 2, if I
Yes.
may, Your Ladyship.
already.
My video is, I'm unable to get my video on since it has been blocked by the host.
Pass tomorrow. Let's
I-
try.
I'm appearing in item number 1 and 2, Your Ladyship.
Oh.
Item 1 and 2, I'm appearing, Your Ladyship.
Okay, let me do something. Yes, then let's see.
Much obliged, Your Ladyship. Your Ladyship, the matter, the writ petition has been filed. There are 2 writ petitions filed before this honorable court. Both have been filed pursuant to a notice issued by the Anti-Corruption Bureau, whereby the notice under section 179 has been issued to Captain Satish Patania as well as Captain Satish Aparajit. Both are personnel both are individuals who are above the age of 70 specifically. Now they have been called to the police station in Mizoram for specific investigations of the FIR registered against them specific. Now section 179 of BNSS as well as section 160 of CRPC specifically states that no person above the age of 60 or 65 can be called to any police station.
Yes, then?
Your Bishop has a BNSS or a CRPC?
Yes.
BNSS. All right. So BNSS section 179. It says, if I may read with your ladyship.
Yes.
Any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself of any person being within the limits of his own or adjoining station. So this is the first limitation which has been crossed or overlapped by the police officer, saying that it has to be within his own limitation, is within the limits of his own or adjoining police station. Second is from whom information given or otherwise appears to be acquainted with the facts and circumstances of the case, and such person shall attend so required. Then comes the proviso, Your Ladyship. Provided that no male person under the age of 15 years or above the age of 60 years, or a woman or a mentally or physically disabled person or a person with acute illness shall be required to attend at any place other than the place in which such person resides. So now, I cannot be called except, and if there is a requirement of any investigation, they have to come to my residence. In order to get any investigation done, I cannot be called to any specific police station. That is the proviso to it. Whereas the original section specifically says that it can only be, the police officer can only require the attendance before himself of any person being within the limits of his own or adjoining police station.
Okay.
I am neither within his.
Okay, what other ground? No, one is you are saying you are above 60. Then the other ground?
The other ground is I am neither residing or operating my business within the limits of his police station or the adjoining police station, Your Worship. Because of these two things, Your Worship, I am also I'm also citing a particular case which is already shared before this Honorable Court, that is Directorate of Enforcement versus State of West Bengal.
But cause of action is Mizoram then?
Regardless of that, the cause of action is Mizoram. I'll cite that case. I'll cite that. Yes, cause of action could be Mizoram, but the police officer cannot call me because the judgment is very clear on that. If I may, page number, if Your Lordship's with me on the judgment.
Para? Which para?
Of the judgment?
Paragraph, yes.
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 Paragraph number 27. So if I may read from 26 onwards.
Okay, please read.
Yes, in order to appreciate the first issue, it is necessary. So there are three issues which were already framed in para 25. And so the three issues were whether the respondent have the power under section 160 CRPC, because this is the corresponding section to CRPC in 179.
Yes, yes.
Other than PNSS. 160 CRPC to issue the impugn notices, whether the present petition is maintainable in the view of the Directorate Information being petition number 1, whether the court has jurisdiction to quash the impugned notices in view of the objection raised as to the territorial jurisdiction, whether the petitioner have made out a case for any interim relief. Now comes para 26. In order to appreciate the first issue, it is necessary to take note of the text of the section 160 of CRPC reads as follows. Now, any police officer making an investigation under this chapter may by order in writing require
yes,
the
this
attendance.
is almost same. Then come to
Same
27.
item, no?
Yes.
Para 27. By a mere reading of the provision, it becomes apparent that the power of the police officer to require attendance of a witness is circumscribed by the word within the limits of his own or any adjoining station. It is to be noted that if the said power was in the nature of pan-India power, as has been sought to be argued by the respondent, there was no reason for the legislature to use the terminology quoted above. To contrary, if the same was intention of the legislature would have clearly stated so and bestowed unlimited jurisdiction to the police officer by using terminology in the nature of anywhere in the country or even anywhere within the state. The clear departure of the legislature and the use of the terms within the limits of his own or any adjoining police station points towards a legislative intent to limit the jurisdiction in this regard. The reliance placed by the respondent in this regard on the judgment of so and so may not further the case of the respondent, as clearly the said judgment was dealing with a separate statutory setup in the nature of National Investigation Agency, which would have a strong bearing on the issue, as the said agency has jurisdiction across the country. Now, the section thereafter, para 28, I am therefore prima facie inclined to agree with the dictum of Ravindra Singh Supra. Therefore, on the issue of the competence of the respondent to issue the impugned notices, a serious challenge has been presented by the petitioner, where prima facie seems to have considerable merit. It may be noted that the said issue goes to the root of the matter, and if the respondent lacks jurisdiction within itself to issue the impugned notices, the entire case of the respondent falls. Now, considering the fact that it has been specifically specified that it is within his own jurisdiction or the adjoining police station's jurisdiction, that is where the person can be called, or that is where the police officer can call the person at all. Now, since I am neither residing or working for benefit or otherwise within the jurisdiction of the Anti-Corruption Bureau within the state of Mizoram, or even otherwise there is no adjoining police station for Anti-Corruption Bureau within the state of Mizoram, I am not there. This particular notice is bereft of any merit. Now, thereafter, I am above the age of 60. Petition number, the first petition, that is criminal writ petition number 7, as well as criminal writ petition number 8. In both the cases, one is 68, the other is 73. I am only to be examined or investigated in my residence. That is, and while we read criminal law, we cannot have any specific otherwise interpretation. We have to strictly interpret the statutes. While we are strictly interpreting the statutes, it specifically says the jurisdiction has to be its own limits or adjoining police station, and the person above the age of 60 cannot be called to any police station. So my residence for petition number 1, for the present petition, writ petition 7 is Delhi, whereas for the present petition in writ petition 8 is Dehradun.
Okay, we issue notice at this stage. Yes. Who's accepting notice?
My lord,
Yes.
I think my learned friend here is confused, my lord. Section 179 talks about attendance of witness only, not accused. And here he is the prime accused, my lord. The scope of 179 cannot extend to the accused.
Yes, attendance of witnesses.
Witnesses only, my lord. Here he is the main accused, my lord, and it's a corruption case, it's a big case.
Regardless of what the case is, what the FIR is, I have to strictly read the provision of the law, of the statute. It says that even for my attendance, I cannot be called at.
Attendance of witness cannot be similar to attendance of an accused person.
But his notice was sent under 179.
Yes, my lord, that is true, but the accused has been summoned in this case, my lord,
Under
not the witness.
179 BNSS. But you have to appear. You appear.
Your Leadership, my appearance as per the section.
Because whatever it is, you have to give your statement.
My statement has to be taken. Come and take my statement from my residence. The section states that if you are to take my statement or investigate the matter, I am above the age of 60. You come and take it from my residence. I have no impediment in giving the statement. But the proviso very clearly states that no person, if I may read the proviso again, if your Leadership may allow me.
Yes, we have seen.
Provided that no male person under the age of 15 or above the age of 60 years, or a woman or a mentally or physically disabled person or a person with acute illness shall be required, the word is shall be required to attend at any place. It is regardless of the police station, it says at any place other than the place in which such person resides. So it is not just that I have to come to Mizoram. It says I cannot go to any place but be there at my residence, and you have to come to my
Okay,
residence.
we'll give a short notice and try to dispose of on the returnable
I have a
date.
Supreme Court citation.
The matter will become infructuous in case this notice is not stayed, Leadership.
No,
Considering the fact
we will not
Lord, he
stay.
has not been summoned for arrest. He has been summoned only to inquire.
We'll
matter
list it
will
after
become
10 days and then we'll try to dispose it off.
it will become infructuous, Leadership.
No, it will not become
of this
infructuous.
month, 28th of this month it will become infructuous because the notice is pending for 28th for my appearance. If I am not to appear by 28th, this matter becomes infructuous. Pointless, Leadership. I will have nothing to say because the cause of action will be.
Where is the impugned order? Page 21.
Page
Summoned
30,
to appear
page 21,
before
no, page
IO
21.
on or before 28 August. Achha.
Yes. So if I do not appear before 28th August, this particular petition becomes infructuous in its entirety. I am coming for quashing of this. The timeline will, I'll be time barred thereafter. There'll be nothing that will remain in this.
No, we'll say no coercive action may be taken against you. This is a petition under Article 226 of the Constitution of India, praying for quashing of the impugned police summon under Section 179 of the BNSS in criminal case number 3 of 2023, registered with the Anti-Corruption Bureau, Aizawl, Mizoram. So, the petitioner has submitted that under Section 179 of the BNSS, it is provided that no male person above the age of 60 years should be required to attend at any place other than the place in which such person resides. So the petitioners, the learned counsel for the petitioner submits that the petitioner is 68.
Petitioner in 7, item number 1 is 68 and item number 2 is 73.
No, we are now dealing with item 1, 68, 68 years of age, and therefore the investigating agency is required to take his statement from his place of residence, and that he should not be summoned to the police station. So, however, by the impugned summon dated 24/7/2025, the petitioner has been summoned to appear before the investigating officer on or before 28 August 2025. At the Anti-Corruption Bureau, Aizawl, Mizoram. Stop. Hence the present petition. Stop. Learned government advocate is present. Learned government advocate such and such, the name again, is present for the state respondents, and has submitted that the petitioner is the main accused in this petition, and that he is required to appear before the IO and to give his statement. Stop. This issue notice returnable on when? Today is 25th. So 2nd September. 2nd September.
First is a little difficult.
On 2nd September, on which date the
That could be 4th, Your Ladyship. 4th is feasible for you?
Excuse
4th
me?
is feasible. 4th of August, 4th of September.
No.
4th of,
No.
3rd of September is feasible, Your
Because
Ladyship.
we will 3rd September. 3rd is DB. 2nd
2nd September.
2nd
okay.
is the
I'll
best.
appear.
Yes, 2nd September, on which day the learned government advocate shall receive instructions as well as a scanned copy of the case diary. Stop. Till the next returnable date, the respondents shall not take any coercive action against the petitioner.
Right.
Item 2.
The identical matter, Your Ladyship, the same notice for
Same.
both. Same notice. If Your Ladyship may see,
Same
page number
order,
21.
but different name, and then the age here will be 70,
23,
73, 78.
73.
Yes, petitioner's age here is 73 years. That's all.
Right, much obliged. Your Ladyship's kind.